Could you imagine living in a country where the head of the government could just decide to pick up anyone off the street any time of day, no matter what, and just put that person in prison for life, indefinitely, without trial, and it would be legal? Could you imagine living in a country like that? Welcome to the United States of America in the era of George W. Bush. You know, the phrase enemy combatant is one of those bits of war on terror jargon that has stopped really meaning anything to us when we hear it anymore. It's just one of those terms that we keep repeating without really reflecting on what it means. But what I just described, the president having that kind of power, that's what it means. Indefinite detention at the pleasure of the president at his own discretion. This approach is now under consideration, finally, by the Supreme Court. Oh, checks and balances. Nice to see you again. The Bush-Cheney post-9/11 worldview has been essentially, we get to do whatever we want. And that executive assertion is at the heart of a new case the Supreme Court has agreed to hear. The case of a man named Ali al-Marri, the only person we know of who is currently being detained on U.S. soil as an enemy combatant. The details are pretty simple. Al-Marri came to the U.S. on September 10th, 2001, with his family on a student visa. He was arrested in Peoria, Illinois, a few months later during the FBI's post-9/11 investigation. Now, initially, he was indicted for credit card fraud and lying to authorities, for which he faced possible conviction and jailing, like a normal criminal in a normal country. But in 2003, President Bush declared al-Marri an enemy combatant, which in this case meant he was sent to a naval brig in Charleston, South Carolina, where he has been for 5.5 years in virtual isolation. Al-Marri's lawyers argue that the president should not be allowed to lock him up indefinitely without a trial. President Bush, of course, argues that he can do whatever he wants, because he's President Bush. Well, now it's up to the Supreme Court to decide, which means there is now a chance that the Bush-era massive assertion of the power of the president will either be ratified by the court and therefore made sort of permanent, or it will be struck down and rendered part of the Bush-Cheney era deviance from what we used to think it meant to be the United States of America. Joining us now is Jonathan Turley, professor of constitutional law at George Washington University Law School. Thanks for coming on the show, Jonathan. Nice to see you.
Hi, Rachel.
Did I describe the al-Marri case accurately there? This is the president saying he has the power to pick somebody up in the U.S. and lock them up, no questions asked, for as long as he wants to.
No, you were absolutely accurate, and you were also accurate in the fact that this runs against every aspect of our constitutional system. It is, in fact, the very definition of tyranny. And you don't hear that term much, but this is how tyranny is defined. It's the ability of a single individual to strip someone of their right to counsel, access to court, and to hold them indefinitely at their own whim. And that is at issue now, and it's perhaps the most important issue that we have, the most important unanswered question from the Bush administration. And the reason this case was accepted, the expectation is that the liberal justices believe they have a fifth vote, probably Justice Kennedy, to finally put a stake in the heart of this theory.
We know that the Bush administration did not want this case to go to the Supreme Court. Does that mean that they expect to lose this case?
I think they do expect to lose it, and it may also mean that they will pull a Padilla. When Jose Padilla was ready to go to the Supreme Court, they found a very technical violation, literally a caption problem in the case, that they were able to get the right wing of the court to send the case back. It was, in my view, an outrageous act, so that the court did not rule on this theory. When Jose Padilla was ready to go back to the Supreme Court, the Bush administration, which always claimed that they were going to fight this one and prove they were right, changed his status. And that may happen here. The Bush administration may have a very good reason to put him into the criminal justice system. They don't want a ruling on the merits of this claim, and they don't want the claim necessarily litigated by an Obama administration.
There is something of a catch here in terms of the politics and the timing and the transition. Because this case won't actually be argued until at least March, it sort of means that President Obama might be able to make very important decisions about this unless they act within the next 45 days to get this guy out of that brig into the criminal justice system, as you say, right?
Yeah, that's exactly right, Rachel. That's the interesting thing. For civil libertarians, this could be a Pyrrhic victory, because if Obama truly is all about change and civil liberties, he would probably come in and say that he's putting an end to the enemy combatant doctrine and move this individual into the criminal justice system. That would moot the case. And for civil libertarians, that would be a very bitter pill, because they don't want just a change of policy. Because if it's just a change of policy and not the creation of precedent, right, then God help us, a President Palin could come back and reinstitute this very same principle.
And the only way to get the precedent set is to have a Supreme Court ruling say this is plainly unconstitutional.
That's right. He'd have to preserve the case. And while he wouldn't make more enemy combatants, let his Solicitor General argue it and kill it with faint praise and allow the Supreme Court to destroy this pernicious doctrine.
Wow. Jonathan Turley, professor of constitutional law at George Washington University Law School. Thank you for your insight. Thanks for joining us.
Thanks, Rachel.